hard to see internet.
All right, we will go on the record now. The time is 6 p.m. This is the hearing for Deschutes County file numbers 24723, 547PA, and 548ZC, which is a request by Caldera Land LLC for a comprehensive plan amendment and zone change of the subject property. My name is Tommy Brooks, and I am the hearings officer in this matter. Before we turn to the substance of the hearing, I'm going to turn things over to Ms. Stewart to describe how the process will work for those participating online and in the hearing room.
Good evening. For the record, my name is Audrey Stewart, and I'm an associate planner with the Deschutes County Planning Division. The item before the hearings officer is a comprehensive plan amendment to change the designation of the property from surface mine to rural residential exception area, and a corresponding zone change to rezone the property from surface mining to multiple use agricultural. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing. This will be followed by a brief presentation on the application. The county has established time limits for testimony as follows: 30 minutes for the applicant, 10 minutes for public agencies, 3 minutes for the general public, and then 10 minutes for the applicant's rebuttal. However, the hearings officer can modify or eliminate these time limits. When the testimony portion of the hearing begins, the applicant will present first, followed by any agencies. Next, persons in support will testify, and then those in opposition will testify. And then finally, anyone neutral to the applicant's request will testify last. Afterwards, the applicant will then be afforded an opportunity to present any rebuttal testimony. And finally, staff can make closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name, as well as your mailing address. For our in-person participants, if you wish to testify, please add your name to the sign-in sheet, which is up here if you haven't signed in. I'll use this list to call up participants for their testimony. After your name is called, please come up to this table here at the front before you begin your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Hearings Officer Brooks asks if anyone attending remotely would like to testify, you'll need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, or if you've called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you're in person, please submit your written testimony to me after your oral testimony. If you're participating remotely, you can submit your written testimony to me via email at audrey.stewart@deschutes.org. Hearings officer and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Are there any objections to the format of the hearing? If you're attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn the hearing over to Hearings Officer Brooks.
All right, thank you, Ms. Stewart. As just described, we are following the normal hearing procedures that are set forth in the county's code, and I will provide sufficient opportunity for everyone to participate at the appropriate time. This application is being considered through a quasi-judicial process. As such, I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and its land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice that announced the hearing. They are also set forth in the staff report. The public notice and the staff report are posted on the county's website, and they are also available directly from staff upon request. It is important that you direct all of your testimony to the standards and the applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, please explain why the criterion must apply and do so with specificity so that other participants can respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail that enables me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval, again with enough detail that allows me to respond in my decision, precludes an action for damages in circuit court. As I just noted, I serve as the county's hearings officer, and in that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record that I do not have any relationship with the applicant, and I'm not aware of any connections I may have to other participants in this proceeding that would prevent me from remaining impartial. I have briefly communicated with staff, but only to discuss the particulars of today's hearing and not the substance of the application. I do not have any other ex parte contacts to disclose. Again, it's my obligation to preside over the hearing in an efficient manner. So at this point, I want to determine how many people are signed up to testify tonight, either because you've signed up or if you're online, if you could use the raise hand function.
Hearings officer, we have one person in the room and one person on Zoom.
Okay. All right, before we begin then, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? Again, if you have an objection to the jurisdiction and you're online, you can use the raise hand function.
And no one in person or online is raising their hand.
Okay, thank you. So with no objections, I'm going to turn it back over to you, Ms. Stewart, to deliver the staff report.
Thank you, hearings officer. I'll provide some background on the application before we move into testimony. The subject property is approximately 65.67 acres in size. It's undeveloped and it's located adjacent to the City of Bend's urban growth boundary to the south of Knott Road. The subject property is listed as mine site number 391 on the county's Goal 5 inventory. Records indicate mining began around 1950, and a reclamation plan was submitted to the Department of Geology and Mineral Industries, or DOGAMI, in 1974. A memo from DOGAMI dated 1998 indicates the file for this mine was being closed out and that reclamation was underway, which indicates that mining stopped at some point prior to that. The applicant requests to change the comprehensive plan designation of the subject property from surface mine to rural residential exception area. They've also requested a concurrent change in the zoning designation from surface mining to multiple use agricultural. This zone change would also remove the surface mine from the county's Goal 5 inventory of mineral and aggregate resources. The application materials include a geotechnical reconnaissance report prepared by a registered engineer. This report shows that pursuant to the state's definition, there's no longer a significant aggregate resource on the property. Less than 500,000 tons of cinder remain on the property, and the report outlines factors that make it difficult to mine any remaining deposits. 4 members of the public submitted comments, and those included questions regarding the future use of the property and concerns about increased housing density, loss of privacy, loss of wildlife habitat, and environmental impacts of both mining and reclamation. Central Oregon Land Watch also submitted a comment today raising concerns about whether the property is agricultural land as defined by statewide planning goal 3. The notice of public hearing was mailed to public agency staff on October 10th, but due to a mailing error, it didn't go out to the neighboring property owners until October 25th. October 25th was 19 days prior to the hearing and didn't meet the 20-day requirement per DCC 22-24-030. Because of that, staff requested the record be left open at the close of the hearing so that anyone impacted has a chance to participate. The public record is available through the link on this screen, and all materials received as of 5 p.m. today have been uploaded. And with that, staff is available for any questions from the hearings officer.
All right, thank you. I do not have any questions for staff at this time, so we can move on to the applicant's presentation.
Materials for the record.
And for the benefit of those online, there is a question about copies of materials submitted today. Everything was uploaded, so it should be available on the hearing webpage.
Good evening, Mr. Hearings Officer. My name is Joey Shear. I'm a planner with AKS Engineering here in Bend. Address for the record is 2777 Northwest Lolo Drive, Suite 150, Bend 97703. I will get my presentation shared here momentarily. So again, thank you for your time here this evening. We are going to try and keep the presentation here relatively short. We have a couple hundred pages of narrative and exhibits that we've already submitted into the record, as well as staff's, I think, very thorough staff report. We appreciate that kind of ongoing collaboration that we've had with staff. We've had lots of questions for them, and we appreciate the time that they've taken to answer those questions. I have about 8 slides here, I think, and then we hope that you will ask us any questions that you have before we wrap up here this evening. So the application before you this evening is the product of a team effort. And fortunately, this team is made up of a group of professionals, engineers, scientists that have prepared all the necessary reports an analysis addressing the statewide planning goals, the administrative rules, and the county plans and code that really altogether make up the decision criteria for this application. As I mentioned, we've had meetings with county staff going back about 2 years, and county staff has been very helpful in answering our questions, directing us to previous decisions that informed our application through precedent and interpretations that other hearings officers and the County Board of Commissioners have made on similar applications. So quickly start by looking at the site itself. Over the years, the site has been called the Shalex Mine and the Miller Pit. Some of the materials will refer to both of those names. It's located here on the south side of Knott Road, due south of the newest high school in Bend, Caldera High School. And you can see here that it abuts the Bend city limits and the urban growth boundary. And the southern end of Bend is an area of town that has been developing significantly over the last 3 or 4 years. The Easton Master Plan there to the northeast, as well as the City of Bend's southeast area plan that they have initiated for hundreds of acres there, like also to the northeast. As Audrey mentioned, the property itself is just under 66 acres, single tax lot. The property is actually the site of 2 former cinder cones that were mined. Again, the record's a little bit spotty. Some of the materials say, late 1940s. Some of them say right around 1950. There were two pits in the middle of the site, the smaller one to the north and the larger one extending to the south. Existing vegetation is typical of what you'd see here on the southeast side of Bend, kind of a mix of juniper trees of varying heights and maturities, as well as sagebrush and bitterbrush. Besides the pit itself, there are no significant resources identified on the property. So no significant resources as mapped by the county. The property, as you can see from the aerial, is vacant. It is not irrigated and does not have water rights. And that is documented in Exhibit J, the correspondence with Arnold Irrigation District. And the subject property has not been farmed or used in conjunction with any farming operation. So here's a short summary of the site's history regarding operations permits and other land use approvals. Again, going back to somewhere in the late 1940s, where we believe mining operation began. In 1974, Dogami issued a permit for the Shalex mine, later granted a certificate of limited exemption due to the fact that it had been in operation prior to 1972, and I think was effectively grandfathered into their permitting system. In 1979, the property was zoned EFU 4, and the subsequent record identified that this was a simple error, overlooking that this was actually an active surface mining site in the all the analysis leading up to the adoption, I think, of what this was the county's first comprehensive plan. This was identified as mining site number 58. And it was, again, just a simple error that this was not designated as such as a mining site when that initial zoning and comp plan came into place. In 1980, the property was formally rezoned from EFU back to surface mine. And again, there's a hearings officer decision with Board of County Commissioner concurrence acknowledging that this was a simple error in that original 1979 zoning. In 1990, after some back and forth, I think an appeal by the Coates family, which owns a large mining area in Central Oregon, the city kind of re-looked at its surface mining zone, went through a much more thorough and lengthy process, identified this site as site number 391, listed it on the Goal 5 inventory, and completed an ESEE analysis that was adopted. And it's important to note that in that ESEE, there was no post-mining use identified. And that is significant as addressed in our narrative. I'm happy to come back to that in a little bit. Subsequent to this, the city has gone through periodic review, had post-acknowledgement plan amendments, all of which did not note this property as agricultural, as farmland, consistently since that time and through to today. It has been designated as surface mine, and that is in plans that have been acknowledged by DLCD. In 1998, Dogami closes his file and finds that, again, because this was subject to a certificate of limited exemption, the reclamation was voluntary, but there was a reclamation plan and it had been completed successfully. So you see here, the subject property is surrounded on the other three sides, west, east, and south, by other property zoned MUA 10, which is part of the reason why we think that is the logical zone for this site to transition to. None of the surrounding properties appear to be commercially farmed, though a few have small irrigated pastures for horses or other kind of non-commercial agriculture or livestock. So this is a summary of, I think, that what we see as kind of the fact pattern or the key facts that would support approval of a zone change for this property. The geotechnical reconnaissance that Audrey mentioned is exhibit D. It confirms that the site no longer qualifies as a significant Goal 5 resource based on the quantity, quality, and location of the resource, which is aggregate in this case. Site number 391 has been voluntarily reclaimed, as I mentioned, in accordance with a reclamation plan that was approved by Dogami and confirmed when Dogami closed out the file in 1998. The subject property is not agricultural land and has not been farmed, and we have detailed analysis to that effect in the submitted narrative. I was not aware that we'd had received any public comment kind of questioning that fact, but we can certainly get into that more if there are questions. The transportation analysis, and we have Joe Bessman, our transportation engineer here, if there are any questions. That is shown as Exhibit G of the application. It concludes that the plan map amendment and zone change complies with the TPR and does not significantly affect any transportation facility. And of course, the planned comp plan designation and MUA 10 zoning serves the public interest and aligns the plan designation zoning with the neighboring properties there on three sides, and also provides a logical transition from the urban zoning in the city of Bend to the north as you move south, and the EFU property that's further to the south. So just to highlight a couple of the exhibits that I referenced, the geotechnical reconnaissance report finds that the material at the site likely never satisfied the OAR Division 230180, which is the standard for significance. The quotes on this slide were pulled directly from that geotechnical reconnaissance report, which was provided by Andy Siemens of Siemens and Associates, a registered engineer who's been working in this area since 1992 and specializes in geologic engineering. The significance determination is consistent with prior decisions in the Tumalo Irrigation District file, which is referenced throughout our narrative, as well as the Tumalo Irrigation District Cascade Pumice file, also referenced in the application. Consequently, to the extent that the site ever met the test for significance in Division 23, the majority of the significant material has long since been removed, such that there is no longer a significant deposit on the site. Here is a snip of part of the Dogami file. It's the memo in 1998 closing out the file. It points out that the reclamation plan was submitted in October 1974 and concludes that the site has been reclaimed. That is the last element of the Dogami file, and this addresses several of the criteria, including Deschutes County Code 1852-200A, which kind of speaks to when surface mining zoning can be terminated or changed. And again, specifically that the site has been reclaimed as approved by Dogami and consistent with the reclamation plan. So again, I said I was going to keep it short. That is the extent of our presentation. Again, we have a couple hundred pages of narrative and exhibits, and I'm happy to try and answer any questions that you might have.
Sure. Thank you. I'm going to ask just a couple questions. The first one's may not be fair because I too hadn't seen the comments from Central Oregon Land Watch about whether or not the property is agricultural. So I assume you're going to want to respond to that, but do you have an initial response to share during the hearing?
Yeah, so I would direct you to our response to the goal 3 that's in our narrative. I think that's probably the place where we most comprehensively address this question. We thought that this question might come up. So I guess to kind of just summarize that here, and for anybody else who's in the room or is online, you know, going back again, the property was designated as surface mining, has been mined since the late 1940s. There is no evidence that we have found of prior agricultural use. The property predominantly consists of class 7 and 8 soils. We did have, the owner a couple of years ago did have a soil study done that was acknowledged by DLCD. That is part of the record. It's an Exhibit F. The property does not have water rights. Again, Exhibit J. And the subject property is not identified as agricultural land on the acknowledged Deschutes County Comprehensive Plan map. The 1980 zone change includes findings acknowledging that the active surface mining sites at the time of the plan adoption, back in 78, should have been zoned SM. The subject property was active and designated as Site 58 on the preliminary map. And again, the quote is, "It was a simple error that resulted in Site 58 not being transposed onto that final zoning map." The property was again identified as containing mineral resource in the Deschutes County Goal 5 aggregate inventory that was adopted in 1988. And in 1990, the county listed the property as site number 391 on the Goal 5 inventory. And these are kind of mutually exclusive categories, especially when there's no post-mining use identified in that ESEE, which is the case here. And that's critical because in Tumalo Irrigation District, which is 247-17-000-775-ZC, the Board of County Commissioners interpreted that a similar ESEE omission on a Goal 5 site would have specified EFU zoning if the property had been classified as agricultural land, and concluded that the surface mining zone was intended to be a distinct zoning and comprehensive plan designation, and the properties designated as other than resource uses, land subject to goals 3 and 4. So there's some additional case law. I am not an attorney, although I did try to summarize it because it's been referenced in several county decisions. It's in our response to goal 3 that again talks about how a quasi-judicial application like this is not an opportunity to relitigate whether something should have been designated as EFU or agricultural. The fact is that there's substantial evidence in the record that it is not, and is not currently zoned as such in the acknowledged comprehensive plan zoning map for Deschutes County. So sorry, a little bit long-winded there, but I guess that, not recognizing that was a comment received, I guess that's how I would answer that question.
I would ask, since it sounds like we need to keep the record open, one thing, at least I haven't found it, is some of these prior Board of Commissioners decisions that are referenced. It would be useful to see the entire decision. So if I don't know, I would put that on the applicant maybe to provide those if you want to. I do think it would be helpful for me to have that whole decision, so I can review, for example, the response you just gave. One other follow-up question I have is just, there's a couple comments in the record already from the public. It seems like if there's a theme to those, maybe it's the questioning about the adequacy of water supplies. So if you wouldn't mind responding to those comments, that would be useful.
Sure. So even though we're proposing that this be zoned MUA 10, I don't think there's any evidence in the record that this site can be commercially farmed. And so I think some of the questions that came in through the comments were about irrigation rights. There are no irrigation rights on this property. We don't have any plan to go after any sort of irrigation rights. So rezoning of the property would not have an impact on any sort of water rights or irrigation rights on this property or the surrounding area. This area is served by Avion Water, which is a domestic water provider. They have main lines kind of running along the south side of Knott Road. I believe we have some information in the record in the will serves. Yeah, there's correspondence dated March 30th, 2023 from Avion Water that they are willing and able to serve potable water to the project. So there should be, with that combination of evidence, there shouldn't be any sort of impact on existing water rights or irrigation rights in this area.
All right. Thank you for that clarification. I don't have any other questions for the applicant. You'll, of course, have the opportunity to come back up for rebuttal if that's necessary.
Thank you.
And was anyone signed up to speak in favor of the application?
I will take a minute to clarify that. And it looks like we've had one more Zoom participant join. So I'm just going to do a quick sort of recheck-in with who signed up to testify. I have one person in support, Dan. Okay, that's with the applicant's team. So could I do a show of hands for those either in person or Zoom that would like to testify in support? Okay, we have one person on Zoom raising their hand.
Okay, let's have that person be elevated, please.
Hello?
Hi, we can hear you.
Okay. I apologize. I was having some trouble logging in earlier, and this subject may have been covered. I was wondering about, since you've kind of broken a fairly large envelope in the earth there, are there going to be testings as far as toxins, radon gas, varieties of things that are, possibly environmental issues? Is there going to be testing of that area?
Just as a procedural matter, if you wouldn't mind first identifying yourself and stating your address for the record, and then following that, what we're doing now is taking testimony for people who are in support of the application. There's not really a mechanism to ask the hearings officer questions. You can raise issues that maybe the applicant can respond to if it feels that that's warranted. But I guess just to clarify, do you have testimony that's in support of the application?
I do not.
Okay. Are you wishing to provide testimony in opposition to the application?
No.
Okay. Thank you. Mr. I think that's everyone that then would have been signed up potentially for testimony in support?
Correct. That would have been anyone in support.
Okay, so let's move to anyone who's identified to speak in opposition to the application.
Do we have anyone in person or on Zoom who would like to testify in opposition? Okay, we have no one in opposition, but it sounds like we have some folks who would like to testify neutral.
Okay, thank you. We will now take that category of participants.
Okay, and if it's okay with the hearings officer, we can start with the person we have in the room here who is in person, neutral, and this is Tom Wurzel. You can come up here.
And so far, I haven't seen any video coming from the hearing room. I don't know if that's possible, if that's working to put the camera on the witness table.
Working here.
Are you currently able to see the person at the table testifying?
No, I just see the Deschutes County logo. I was able to see the applicant's presentation, but not the video of the speaker.
Okay, we are gonna on our end try and figure this out while this person's testifying. If not, it should at least appear in the video recording of the hearing.
Okay, great. Thank you. Please proceed.
Yeah, my name is Tom Wurzel. I live at 60604 Woodside Drive in Bend. I have the property just south of the property that's suggested to be rezoned. And mine are somewhat questions, but also what I heard here. So I put myself in a neutral category. Right now, that property has two very large holes where they were doing the mining. And the comment was made in all the documentation that it was reclaimed and that reclamation was approved. And I know when I go see it, it's just still two large holes that separate my property from Knott Road. And our concern is when we purchased the property, we were made to sign a document that said that we have a surface mining property adjacent to our property, and that if they ever decided to start again, we had to accept that. And thank goodness nobody has done that. So when they say it's reclaimed, our concern always is, well, what does that mean? It's just going to stay the same as it is, and somebody's going to try and figure out how to build 10 houses on that property if it's zoned MUA 10, or if it's going to be just a huge project to fill it in. And basically, how does that have to get approved separately from this process? Or if the agreement is that the zoning is approved, then can they do pretty much anything they want to again reclaim the property in another way? I guess is kind of our concern, is the impact to our property.
All right, thank you for those comments. I will give the applicant an opportunity to address those if they want to.
Thank you. And that was our only in-person participant who wanted to testify. Seeing that, just to check again, anyone on Zoom who would like to testify, neutral or someone we might have missed over before, please raise your hand through Zoom. We don't have any hands raised on Zoom right now.
Okay, it looked like there might be one hand raised, at least the list that I'm looking at. But can you just confirm?
Yeah, we'll call them up. That was the person who testified earlier, but we can see if we have any additional testimony.
Got it. Let's do that just to make sure, please.
Okay, can you hear me?
Yes, did you change your mind about providing testimony?
Well, I didn't, like I said, I had trouble logging on. I joined late and I didn't realize I was providing testimony in the pro side. So I was going to just, add the comments as a neutral source. It was actually more of a question. I don't know what the format is. Will you take questions about certain things at this point?
I will allow you to continue to provide testimony if it's just be aware, I guess, if it's in the form of a question, you'd be just sort of posing that question, and it will be up to other participants to decide if they want to respond to that. But it's not something that there's really a mechanism for.
Oh, so you cannot ask questions?
The process right now is for you to provide testimony about the application.
Oh, okay. Well, then maybe I have nothing to say. At what point will questions be allowed?
Well, there's not really a mechanism now for questions to be, I guess, asked, at least at the hearing. If you want to phrase your testimony in the form of a question, I will give the applicant an opportunity to decide if they want to answer that or not. After my decision, the decision does go to the County Board of Commissioners. It would be a similar process, though, where you would be providing testimony on the application.
I guess I don't have the ability to provide testimony because I would need an answer to my question, which was about would there be any testing of environmental toxins in the area? I don't know, arsenic, lead, radon gas. I mean, you've opened up a deeper section of the envelope that protects the surface. What sort of things can you expect or contest for that would be an issue? So
okay, thank you. That sounds similar to the question you posed earlier. And so that's now in the record, and of course I'll let the applicant decide if that's something they want to address or not. Thank you for your comments.
And hearings officer, it looks like we do have one other Zoom participant who raised their hand.
Okay, let's elevate that person.
Good evening.
Hello.
So my testimony is neutral.
Could you please identify yourself for the record? I'm sorry.
I'm so sorry. Kimberly Peterman, 60645 Tecampie Road in Bend, on the opposite side of the gentleman that first did the neutral testimony. Excuse me. So my only concern, the biggest concern with having this changed in the zoning is the reclamation process that would happen. I do see that Dogami says that it was reclaimed. However, the standards for reclamation in the 70s were nothing near what they are at this point in our lives. And so my concern is that there needs to be a lot more. As stated earlier, there's not a lot. There are 2 huge holes in the property. So while I'm not necessarily against it, I have concerns regarding the process. And I know we can't ask questions at this point, but I guess it's kind of leading towards that too, of what point do we get to get some information on that?
Okay, thank you for your testimony. I believe that concludes everyone who's signed up. That's not the applicant. Is that correct, Ms. Stewart?
Correct. No one else on Zoom or in person is raising their hands.
Okay, then I will invite the applicant back up for a rebuttal.
Thanks for the opportunity to rebut again. Excuse me, Joey Shear with AKS Engineering. I'm happy to try and answer a couple of the questions that we heard from Mr. Urich, who was asking about environmental testing. So I think I'd first note that there's nothing about environmental testing that is decision criteria for the current application. That being said, as part of this team's due diligence, we did have a phase 1 environmental done on the site that returned no indication of any sort of environmental issues or pollution. So that's what I can tell you at this point today. Again, that's not in the record because it's not related to any sort of decision criteria, but it is some analysis that this team has undertaken. The questions from Mr. Wurzel and Ms. Peterman regarding reclamation. So again, not being an expert on mining or dogami processes, I'm probably somewhat limited in kind of a detailed analysis or response to those questions. What I can say is that the test for the current application is whether the site was reclaimed in accordance with a plan approved by Dogami. And I think we have substantial evidence in the record that that is the case. Again, referencing Exhibit E and pointing out that because this site did have a limited exemption because it predated 1972, the reclamation was voluntary. The site would not have been required to do reclamation, but the reclamation that was done was voluntary, was part of a plan that was approved by Dogami. And then in the 1998 memo, Dogami acknowledged that the site had been adequately reclaimed. Going forward, I mean, I think the general question is there are signs of mining still on the site. And so, and I understand that folks are concerned about future development, especially on neighboring properties. I think I totally understand that. I think that's perfectly appropriate. I would say that is not directly related to the application before us this evening. There will, future development of that site would have to do some sort of site work. But again, there are no current plans for development of that site. And those issues would be addressed with a future land division or site plan review, some future land use application where there were specific plans laid out and a notification and public process. As far as reclamation subject to the current application, I'll just say that the evidence in the record is that this site is meeting the test that's required for a comp plan amendment and zone change.
All right.
And Officer Brooks, I don't know if you had any further questions for the applicant. I'm happy to try and answer those at this time.
No, I don't think I have any specific questions, at least about the substance of the application. I think we can start to wrap up that piece of it. I did hear staff say that they would like to have the record left open. So I'll probably talk to staff about that a little bit. But just if you have any comments about leaving the record open or any preferences for amount of time.
No, I think that's fine. And I think probably the standard 777 would be agreeable to the applicant. Yeah.
Okay. All right. Then if you don't mind, I'll bring staff back up, so to speak.
Okay, thank you, hearings officer.
Yeah,
One I wanted.
Go ahead.
One thing I wanted to note regarding the questions around sort of review of fill that's put in and grading. So if an application for a subdivision was submitted within our subdivision criteria, so chapter 17, there's 1713 is design standards, and there are some requirements in there regarding cut slopes and the composition of fill, et cetera. So that's kind of the time that we would review some of those questions around how the site's being filled in. Beyond that, staff doesn't have any additional questions. If the discussion of the open record is settled, I do have a couple notes regarding sort of record submittals.
All right. Ms. Stewart, I was probably not paying close enough attention when you talked about just the hearing notice and the dates to leave the record open. So was the hearing notice not sent out on October 10th?
It was sent on October 10th to public agencies and those who had submitted comments to me directly. But pursuant to Title 22, which is our procedures ordinance, this notice required a 250-foot mailing radius. So that 250-foot mailing radius was left off of the October 10th mailing, and they were noticed on October 25th. And so that was why staff requested the open record.
Okay, thank you for clarifying that. That helps. And I think it does make sense then to leave the record open in light of that. If you wouldn't mind, as part of, I guess, a quick memo from staff, just to make that correction, because in the staff report, it doesn't draw that distinction. It would be helpful to have some memorialization about the date of that notice.
Mm-hmm. And staff can upload that as an additional memo to the record so
Okay.
that the staff report isn't revised retroactively. Mm-hmm.
Okay. So in just a minute, we'll have staff help us calculate the dates, but there's been a request, and I'm going to grant it, to keep the record open for what we refer to as a 777 period. So the record will be left open for any participants, whether they were here tonight or not, to put evidence into the record about the application. The record will then be left open for an additional 7 days for rebuttal to any new evidence, which would include any evidence that came in today with the hearing, and then a final 7-day period for the applicant without any new evidence to offer a final legal argument if it wants to. So with that, Ms. Stewart, do you have those dates calculated?
Yes. So the 7-day open record period would end at 4 p.m. on Monday, November 20th. The 7-day rebuttal period would end at 4 p.m. on Monday, November 27th. And the applicant would have until 4 p.m. on Monday, December 4th to submit their final legal argument.
Okay, and can you provide instructions to the participants for how to submit things on those due dates?
Yes. So here are some notes to keep in mind for the open record period. All submittals should be addressed to me. For email submittals, use my email address, which is here on the screen, audrey.stewart@deschutes.org. The county does not retrieve information from a website link or personal cloud storage device. It's your responsibility to submit all evidence and testimony you want the hearings officer to consider. Any electronic submittals must be received by the county's server by 4 p.m. Please do not wait until the last minute to submit your evidence and testimony. And with that, staff doesn't have any more comments.
Okay, thank you. So with that, we're going to close the hearing. I'm going to leave the record open as was just described for written submittals only. And the record will remain open until that time. And we will now go off the record for tonight. It is 6:51 p.m. Thank you, everyone.